Now, I've been a criminal defense paralegal for 5 years. I've been a paralegal in general for 8 years. And so I think I'm well versed to, discuss this topic. What's up, guys? My name is Danielle. I am a criminal defense paralegal in Maryland. And on this channel, I focus on all things paralegal, grad school, motherhood. I share my entrepreneurial journey. I essentially create lifestyle content. I vlog my life essentially and share it with you all in hopes that I'm able to help someone along their journey. Okay. So I don't really have a niche, I don't really have like a set thing that I do. I do everything. So if that sounds like something you're interested in, please subscribe to this channel. All right. I want to apologize in advance because one of my children brought me home an unwanted gift in the form of a cold. So I am quite nasally and congested. All right. Now, in today's video, we are going to focus on how criminal defense paralegals assist in preparing for trial. Now, I've been a criminal defense paralegal for 5 years. I've been a paralegal in general for 8 years. And so I think I'm well versed to, discuss this topic. I do have my notebook here because I have to stay organized. I have ADHD, and without this, girl, I'd be all over the place. So if you are interested in how paralegals assist in preparing for trial, please stay tuned. All right, guys, first things first. This is imperative for you to know. If you are not yet a paralegal and you're thinking about becoming one, just know that you will do majority of the heavy lifting, okay? You're going to do majority of the heavy lifting. And I like to compare it to like a nurse and a doctor, right? Like the nurses do all of the heavy lifting. The doctors come in, white coat, do their thing. But like, girl, you done spent more time with the nurse and the support staff than the doctor, okay? You got about 5 minutes with the doctor. That's how it is with these attorneys. They're busy. They're busy. That's why you're there, baby. You're the buffer, okay? And this is Bean. He just wants to be in the mix. The first thing that you are going to do in preparing for trial is obviously speak with your attorney. Your attorney is going to provide you with very basic information regarding the case, okay? Because in the very early stages of the case, the attorney does not have all of the information. He or she may have, obviously, what the client is charged with and statement of charges, maybe even, a little police report or something. But, sorry guys, so sick. But essentially, they don't have much. So they're going to tell you what they have. So they'll tell you like, well, this case is relating to X, Y, and Z. The client is being charged with X, Y, and Z. And that's about it, If they have the police report or the statement of charges, obviously you will get a copy of that. You'll read it so that you'll be able to have a little more insight, but essentially it's just a waiting game until you receive discovery, which takes me to number 2. Now, you as the paralegal are going to receive discovery from your attorney. Your attorney receives the discovery from the prosecutor, okay? So the prosecutor is obviously the person who is prosecuting the case, right? Oftentimes we see on like TV shows and things of that nature is defense counsel and the prosecutor. The prosecutor is the one who has all of the information that we need as defense counsel. So they will send over the discovery for the case that they are prosecuting your client for. Once your attorney receives that, he or she will then share it with you. Once you get the discovery, it's game on, baby, okay? Because it is absolutely imperative that you go through discovery carefully, because first and foremost, there's going to be a shitload of information that you receive when you get that discovery. So discovery can consist of, but is not limited to, video footage in the area of the alleged crime, okay? You're obviously going to have the body-worn cameras of the police officers, which is simply the cameras that they are supposed to wear when engaging with the public. You're going to get paper discovery. So you may even get medical records. You are going to get witness statements, victim statements, your client statements if they've made any. So discovery is very important because this is when you get to see everything that happens in the case. And it is a lot of information to take in. It takes days and days and days to go through discovery, particularly if it's voluminous, which 9 times out of 10 it will be, okay? Now, step number 3 is to identify legal issues in the discovery. Any type of discrepancies that you notice in the discovery, you need to make note of it, okay? Meaning, if you are going through your discovery and you notice that you see a potential suppression issue, you need to make a note of it because this is going to help us in our future steps. So go through all of your discovery. You're making notations of things that just don't add up. You're making notations of things that, oh, well, they said this in this clip, but in this clip is something else. The victim stated that the perpetrator had on this color shirt, but in the video, my client has on another color shirt. All of these things you have to make note of. Essentially, you need very good analytical skills. You need to pay attention. You need to be on your P's and Q's. And sometimes it may require you to get up and walk away from the desk and walk away from the computer. Give your eyes a break because it's a lot to do, okay? Now, once you have made notations of all of the discrepancies that you see in the discovery, any issues that could be legal issues in your discovery, we're going to move on to step 4. And step 4 is to draft motions regarding the legal issues that you noted in step 3, okay? Meaning, like I said, if you notice something that could be potentially a suppression issue, you want to make a motion for that. You're going to draft a motion for that issue. An example of this could be the way in which an officer obtains a client's cell phone or property off of their person. If it in any way violates the client's constitutional rights, that is a suppression issue. So as a paralegal, obviously, you know it's important to know when someone's rights are being violated. You obviously have to know the laws and things of that nature. And if you are new and you're starting out, you will just have to converse more with your attorney and tell him or her that you think this may be problematic. If he or she agrees, you are then going to do legal research. And even if you're not sure how to do the legal research is obviously going to give you the answers to your questions, but it's going to also educate you in the process. I have a video over on my TikTok on how to do legal research. I also have a long form video here on YouTube on how to conduct legal research, all right? But it's imperative that you do the legal research because inside of your motions, you need to reference other cases that have had the same legal issue, okay? And that ended up having a favorable outcome, because the point of a motion is to basically persuade the judge, or the court rather, to keep out certain information. So you want to show that it was obtained in a way that violated the constitutional rights of the client. You're going to argue to keep that out, all right? So in order to do so, in order to make sure that your motion is heavily supported, you have to reference other cases that this has been an issue in, and how the judge in that case ended up voting, essentially. Step number 5 is, once you've drafted your motions, you're going to take all of the motions and or other legal documents that you've drafted and provide them to the attorney. So obviously you're going to draft motions, or you may even need to subpoena records because you notice that something is missing from the discovery. You're going to take all of this and you're going to give this to your attorney. The attorney is then going to read over everything that you've drafted, and 9 times out of 10, especially if you've been working with your attorney for quite some time, you know how he or she likes things written, and you know what he or she looks for when they're drafting certain documents or things of that nature, because you've been working with this person for so long that you know how to essentially write the way in which they like. So if everything is up to par, which I'm sure it will be, the attorney is basically going to go ahead on okay your motions. Obviously, they have to go over it because you are not a licensed and barred attorney, but they'll okay it, and then they're going to send it in. And then after that, it's out of your hands. You know, we're just waiting to see if the motions are granted. We're waiting to see if we get the records that we've subpoenaed, okay? After that, which is now step number 6, we are going to prepare a trial notebook. Now, for me, I like to prepare hard copies and digital copies, okay? So I prepare my trial notebooks in the form of a trial notebook, obviously, that you can take to court with you. And then I also have it in digital form. Your trial notebook is going to consist of an array of things. It's an array of information that goes into trial notebooks, and it would be like a long ass video if I say here everything that is in a trial notebook. Yes, sir. Now, once your trial notebook is complete, we want to circle back around and check on our subpoenas. If we have not received the information that we requested in our subpoena, we want to circle back around and get that information, because now remember, information that we request in subpoenas could be lengthy and voluminous as well. So we don't want to wait to the last moment to check back on it, because if it is a lot of information, we will be right back at square one, where we have to go through everything all over again, and that's just not something that you want to do, okay? So we are going to check on our subpoenas, okay? Number 7, it's time now to obviously reach out to your client, okay? We're going to reach out to our client, and this means that you will be responsible for speaking to the client. Because you're responsible for speaking to the client, to and with the client, it may require you to have to go to facilities, and facilities meaning prisons or jails or halfway houses, wherever the client may be. You will obviously have to go to them. Now, for me specifically, I work with felony attorneys, so majority of my clients are incarcerated, so I have to physically go to the facilities to see them. In some cases, we are able to do Zoom meetings and things of that nature, but for the very first meeting, I like to make sure that I do a face-to-face meeting. I just feel like a face-to-face meeting is more personable and the client with a sense of trust, and just you showing them that you feel that they're important enough for you to come out and speak with, okay? Now, during the interview, you always want to make it very clear that you are not a licensed and barred attorney. So because of that, you cannot answer any legal questions, okay? Now, as the paralegal, you're going to know the case inside and out, and sometimes better than the attorney. Even with that being the case, you cannot provide any legal advice to this person because you are not a licensed and barred attorney, okay? Essentially, you're going to know the case. You're going to know the answers, and it may be hard for you to not answer the question because you know the answer, but you have to keep in mind that you just cannot give legal advice, all right? So you want to make that very clear from the beginning, all right? After you've met with your client, you've got their point of view, you've gotten what happened from their perspective, it's time now to meet with potential witnesses, okay? Now, in meeting with the witnesses, you want to make it known that you are a paralegal for defense counsel, okay? And that you're here to ask a few questions regarding X, Y, and Z, okay? And if you work for an agency or even a law firm, it's important to note that you need to have some type of identification on your person when you go out to meet with these individuals. Like, I always wear my work badge, okay? Because, like, you don't want to look as if you're just a random person coming up to this person and trying to talk to them, all right? Now, I'm going to tell you what I do. I'm not saying that you do this, but I'm going to tell you what I do, okay? I live in Baltimore, Maryland. Okay, I am a female that's 5'2" and 155 pounds. Okay, as I stated, okay, I work in the felony division, so a lot of the crimes that my clients are being accused of are heinous crimes. All right, so when I go out into the community, because 9 times out of 10, if the witness is a witness, he or she may be out and about, like they're out in the community. So you'll have to go into different neighborhoods. You'll have to go at different times. You will have to go into people's homes, although I don't advise that you do that. But sometimes it's not the most favorable of places to be. Again, I love my job, but not that much to lose my life. So whatever you do, you want to make sure that you're doing it in the safest manner possible, okay? And if you do need to be safe, if you're in a state that allows you to get your conceal and carry, I would advise that you do that. But at any rate, ensure your safety, okay? Now, once you get there and you feel comfortable and you're safe, you're going to ask the witness an array of questions, okay? And some of the questions are quite general, but then there are other questions that are specifically tailored to the case in which you're working on. And if you want, I can make a video about how to interview a witness for a case that you're working on. If you want that, just put that down in the comments below and I'll be sure to get that video out to you. Once you get all of the information from your client and the potential witnesses, and even the victim, because sometimes you may have to interview or speak with the potential victim. It's very rare, but it may happen, okay? Now, once you have all of this information, we're going to move on to number 8. Number 8 is to take all of that information and plug it in and see how the information that you now have can be utilized to help with defense counsel's defense for the client. So around this time, you and your attorney are going to discuss different types of defenses, obviously, for the case, and see what makes sense and what doesn't. See how this fits in where and things of that nature, right? Now, obviously, things are subject to change. So you want to stay in constant communication with your attorney during this. All right, step number 10, the last and final step, is that you want to ensure that your attorney has met all of his or her deadlines with making sure that they have all the exhibits planned out. If they have any witnesses that they're going to call to the stand during trial, if we're going to put the client on the stand during trial, with police officers they're going to call, if they have all of the information that they need. So this is these steps are very strategic in the sense that now we're just lining everything up to ensure that when trial happens, we're prepared. We're checking off lists, right? And again, I can make another video about that, but I have a very specific and particular list that I use when I'm asking my attorneys, okay, did you file this? Did you do this? Because there are certain time frames that attorneys have to have information sent in. And if it isn't, then child, all hell breaks loose. Okay. Now, believe it or not, as the paralegal, you're not just the paralegal, right? You are the calendar keeper, right? You are the, did you do this? Did you, like, you're essentially annoying as fuck. You want to make sure that your attorney is on his or her game, because let me tell you, they forget. They forget. And you know why they forget? They forget because they have so many other cases that's happening all at once. So simultaneously, there are so many things that are taking place. Child, they forget. And because they have so many cases that's taking place all at once, you do too. But the only difference is you can't afford to forget, babe. Although they're being paid more than you, you're doing a lot of the work, and you are also reminding them that they have deadlines to meet. Stay on their ass. That's how it is with your attorney. Like, you want to make sure that they have everything lined up so that when they get in court, this is their time to shine. Now, you done everything you were supposed to do. Like, got them up until this point. You've built the foundation up. The attorney's job now is to shine. What were you gonna say? Bright like a diamond, okay? It's their time to shine. And that's essentially what you're there for, to ensure that the attorney has the space and the availability, the freedom to really immerse him or herself into the defense and into all of the ways in which they may try to argue this or argue that or do this or do that during trial, okay? Because it's too late. Once we're in front of the 12 individuals, it will be, or the bench trial, which is just a judge, but it'll be too late to try and figure out certain shit. Like, that's the time when the attorney shines, okay? So you want to make sure that you do everything in your power to make sure that they win this case. That it's not up to us to judge whether the person is innocent or guilty, because there are plenty of innocent people who are jailed and who have spent decades in jail for something that they did not do. We just want to make sure that the individual has a fair shake at trial, okay? That basically wraps up the video, guys. If you found this video helpful, informative, or anything of the sort, please like this video, share this video, subscribe to this channel, okay? Your girl's trying to get her numbers up. Thank you so much for spending some time with me and watching this video. I will see you in the next one.